So hello and welcome once again to our second session for today with the subject of the rule of law. Our first speaker should be Professor Marijan Pavčnik. So Professor Pavčnik will be speaking about the argumentative nature of the rule of law argument. Professor, the floor is yours.
Thank you very much. First, I would like to say hello to everybody. And while it is a pity that I am not in Belgrade, but okay, I will try to speak per Zoom. As you said, the title of my paper is Argumentative Nature of the Rule of Law Argument. I would like to speak about its elements and some open questions and cases. First, introduction. The main task of my paper is connected with Professor Postema's statement that the nature of the rule of law argument is argumentative. This is also Professor Nick McCormick's thesis. My ambition is to present the main elements of the rule of law argument which have to be substantiated. The time I have to present my paper doesn't allow me to be exhaustive. I will speak about the concept and the elements of a state governed by the rule of law and about the rule of law argument as a legal principle. Second, the concept and elements of a state governed by the rule of law. A state governed by the rule of law is a modern state, where the actions of state bodies are legally determined and where fundamental rights are guaranteed. The design of the modern state governed by the rule of law is a result of historical development, which with the most intensive contributions coming from English, later also North American and European continental law. The original elements of the English common law rule of law are supremacy of the parliament in relation to other state bodies, equality before the law, and the protection of fundamental human rights before courts. Fundamental rights exist already before that power, and thus, as a substantive principle, define the limit that the state power must not violate. This insight was also accepted by the continental, especially German variant of the state governed by the rule of law, which originally put more emphasis on the legality itself of the state organization, hence the expression Rechtsstaat, and the subordination of the administration to status passed by the representative body. It is generally accepted in modern theory that there are no essential differences between the European continental Rechtsstaat and the Anglo-American rule of law. Even more clearly, the rule of law is the result and the aim of both systems, and they understand it very similarly as regards its contents, while they approach it in different ways depending on the differences between the two families of law. In a state governed by the rule of law, legality is a quality that is specially emphasized. It holds true for such a state that the Constitution, the statutes, and the other formal legal sources treat legal subjects equally and foreseeably. Violations of the law are also defined in advance. Of special importance is the principle nullum crimen nulla pena sine lege certa, and the procedure used by the responsible state body in order to establish whether a violation of law has taken place and which legal consequence should be pronounced. This is the so-called the principle of legal certainty. In a state governed by the rule of law, the rights and duties of legal subjects are defined by the law. The most important among them are contained and promulgated as the fundamental rights in a legally formal manner by the Constitution or some other constitutional documents. Another element of a state governed by the rule of law are the legal remedies used by legal subjects to exercise their rights and achieve the realization of duties. Third, the rule of law argument as a legal principle. The rule of law argument is by its nature a legal principle which differs from legal norm. One can say for legal principles that they are value criteria directing the definition of legal norms as regards their contents, their understanding, and the manner of their enforcement. In positive law theory and in legal practice, legal principles are often not sufficiently observed. For many, the main guideline is still the legal norm, for some even just the legal regulation, legal provision, constitutional provision, article of the Constitution, and so on, and not also the legal principle, though both legal guidelines are closely connected to each other. Norms without principles would lose their direction. Principles without norms lose their variety with regard to content, as well as their foreseeability and firmness of their meaning, which would result in an unprincipled and arbitrary legal adjudication. In short, the law is a system of legal principles and legal norms, and within this whole there are differences that have to be considered. It must not be said either of legal norms or of legal principles that the former are applied directly because they are ready for subsumption from the very beginning, where for the later, the evaluation of value consideration, assessment, nuancing, and so on is of central importance. In either case, it is subsumed in the end, and legal consequences are deduced. With legal norms, the interpretative path is, as general rule, shorter and less complex, whereas with legal principles, the interpretative procedure is, as a general rule, longer and more complicated. In either case, the decision is only possible once the norm, principle, has been chosen and when also its meaning has been accepted. A few examples will follow to illustrate how legal principles, also the rule of law principle, are used in practice. The legislature has the most leeway. Its duty is to remain within the limits of the legal principle, but at the same time, it is the one to concretize the principle as regards its contents and to operationalize it. It co-depends on the contents where the principle ends and where its limit is. Similar is the role of the Constitutional Court, when it judges whether a statute or some other normative legal act is in accordance with the legal principles, for example, the rule of law. When the Constitutional Court decides on a constitutional complaint, it judges whether a concrete decision is in accordance with a corresponding fundamental right. The duty of the Constitutional Court is to consider those constitutional principles against, for example, the rule of law principle that co-determine single fundamental rights regarding their contents. At the same time, it must gauge or measure the fundamental rights themselves which are under discussion. Many fundamental rights has already the nature of a legal principle if it contains various standards, for example, the principles of human dignity and of trust in law, which are characteristic of legal principles. Before regular courts and other state bodies, it is, as a general rule, impossible for a decision to be directly based on fundamental legal principles. An exception are legal gaps. Regular courts use legal principles indirectly. It is via legal norms on which they directly base their decisions. Here, the rule of law principle can have an important role. Its influence is especially felt in pre-criminal and criminal proceedings before administrative bodies and before the administrative court, for example, the question of using one's power of discretion. Thank you very much for your attention. Let me add that I will that I will follow this conference only to hear the paper of Professor Jasminka Hasanbegović. Then I have to leave the conference. Please excuse me. Thank you very much again.
Thank you very much, Professor Pavčnik. Since the professor has other obligations, I propose that we make a slight exception to the discussion at the end rule and perhaps ask right away if anyone has questions for Professor Pavčnik, since he won't be able to stay until our scheduled discussion time. Or maybe we can...
I have a question. First, Marijan, thank you very much for your presentation. I would like to hear from you, not as a legal scholar, but as a judge of constitutional court in Slovenia. Did you find or how often you find this rule of law argument in first in documents that let's say constitutional complaints or in any other procedures that you have in constitutional court in Slovenia, and if it is so, what conception was in it? Because we have a pretty good, I wouldn't say definition, but I would say determination of the rule of law in our constitution, but I'm not that much aware of that, using that argument in practice. Maybe the situation is different in Slovenia. It would be nice to learn something about that. Thank you.
Thank you very much, Jasminka. I am not quite sure that there are great differences between Serbia and Slovenia. Very famous decision in Slovenia was the question whether it is allowed to have Tito Street in Ljubljana. This case was before the Constitutional Court, and the Constitutional Court decided that it is not allowed to have Tito Street in Ljubljana because it is not in accordance with the human dignity. And well, this was the decision that was taken by our Constitutional Court. I am not going to comment this this decision, but anyway, they used the human dignity argument, and they said it would be not in accordance with human dignity whether it would be allowed to have Tito Street again in Ljubljana. This is, in short, answer to your question, Jasminka.
Just a footnote. Did you write the majority opinion? Marijan, did you write the majority opinion?
Sorry?
Did you write the majority opinion?
No, in this case, I didn't wrote it because at that time I was not yet the constitutional judge, but I would perhaps I would write, let me say, this opinion.
Thank you, because you sent it to me, the whole opinion. That is why I thought that it was your authorship. Sorry.
Thank you. Are there any more questions for Professor Pavčnik, as he won't be here later on? If not, thank you very much, Professor, once again. And we are moving to Professor Jasminka Hasanbegović, who will be talking about the sovereignty of law as Postema's element of the rule of law, critically reconsidered and specified.
Thank you. First, I have to start by apologizing as well as thanking Bojana, Juris, Isabel, and Marijan, Igor, and Tanasie, because they have already heard this argument of mine and helped me to precise and sharpen it. In the third chapter of Gerald Postema's Law's Rule, he stipulates that the sovereignty of the law is an element of the rule of law. I quote, according to the UN report, the rule of law is a principle of governance according to which all entities that exercise power, public or private, govern with and are governed by law. We must not fail to appreciate the boldness of the rule of law's claim. Its unequivocal demand is for law alone to rule. The end of quotation. But how law as the sovereign and the ruler should be conceived? Should law be conceived as a legal order, or should law be conceived as a set of all legal regulations in the country, ideas encompassing the constitution and statutes and bylaws? Or should law be conceived just as a constitution in terms of the basic law of a country by which all entities are ultimately legally determined and governed? Or should law be conceived in any other more or less similar or different way, implying so many thin and thick conceptions of the rule of law? When we analyze in greater detail Andrei Marmor's article, The Rule of Law and Its Limits, it becomes clear that its author sees the rule of law similarly as German authors saw the Rechtsstaat from its first theoretical definitions until the beginning of the post-Second World War era. Or as Lon Fuller sees the internal morality of law, as ruling by general, publicly communicated, non-retroactive, clear, non-contradictory, implementable, stable, and consistently applied laws. Only such a conception of the rule of law that equates the rule of law with legalism per se in a narrow sense, Marmor can declare, I quote, "Even if the rule of law is a good thing, too much of it may be bad." The end of quotation. Following an initial shock, it leaves us speechless, but when one considers this opinion in line with Spinoza's advice, non ridere, non lugere, neque detestari, sed intelligere, i.e. not to ridicule, not to lament or detest, but to understand, one can notice two things. First, if the rule of law is reduced to legalism per se, then the rule of law is an unnecessary concept from the aspect of both legal theory and legal practice, since the concept of legality per se then suffices, where it, in a wider sense, includes constitutionality per se and legality per se, thus making the concept of the rule of law redundant because it represents only a different name for already familiar and identified legal concepts and phenomena of constitutionality and legality. The second important thing is that such concepts of a rule of law are devoid of any content, though it is well known fact that worldviews and ideologies, primarily political ideologies, are determinative and decisive for legal order, so that they may lead to completely different applications of even identically formulated legal provisions, as it has been demonstrated and proven in many relevant legal studies. Here, the question arises, what is a relationship between the rule of law and sovereignty? If sovereignty is understood as the legal unlimitedness of the state, which is a traditional understanding of the sovereignty as the power that establishes or changes the existing law, or establishes and amends the existing legal regulations, then the rule of law and sovereignty are incompatible, irreconcilable. So, in that view, the sovereignty of law cannot be an element of the rule of law or the law's rule in Postema's wording. Such a view on sovereignty can be found, for example, in the Oxford Dictionary of Law. Sovereignty is supreme authority in a state, assigned to the institution, person, or body, having the ultimate authority to impose law on everyone else in the state, and the power to alter any pre-existing law. The end of quotation. But if sovereignty is understood just as legal supremacy, but not as legal unlimitedness, hence as supreme but limited authority to establish and amend existing law, existing legal regulations, then and only then are the rule of law and sovereignty compatible, reconcilable. And now we face another question. Who and what is to limit the sovereign in the rule of law? Or rephrased, the question is, what legal limitations should be imposed on politically sovereign authority which has legal supremacy on a state's territory in order to have the rule of law. These limitations should be human rights, constituting human rights law. In the history of ideas, this idea was expressed metaphorically but clearly for the first time by Sir Edward Coke in his powerful line. I quote, "Magna Carta is such a fellow that he will have no sovereign." The end of quotation. Human rights law limits the sovereign and anybody else too in social and national or supranational orders of the rule of law, although the sovereign remains the supreme legal authority in such a community, polity, or state. In other words, human rights law is the higher law, it is the highest law, with which all other laws, as well as all other decisions and actions, both by those in power and all other subjects within a specific order, must be aligned for that order to be qualified as the rule of law. Hence, it could be said that human rights law is politically and legally sovereign within such an order, since it limits everybody and everything within it, including the supreme legal authority, ideas, constituent or legislative powers, as the legally highest but still limited state powers. In the rule of law, there is no complete parallelism between the legal and state hierarchy. Let us elucidate it in more detail. In the rule of law, the hierarchy of state authorities, which includes constituent power holders or constitution makers, lawmakers, sub-legislative authorities, courts, and administrative organs, ideas, the state hierarchy is asymmetrical with the hierarchy of the corresponding legal instruments, which includes the Constitution, codes, laws, statutes, regulations, ordinances, decrees, bylaws, judgments, sentences, verdicts, charges, taxes, fees, tolls, tributes, and other non-general, singular, individual, concrete decisions. Why is it so? Because in the rule of law, it is human rights law that is at the top of both the state organs hierarchical pyramid and the legal instruments hierarchical pyramid. And this is so regardless of whether human rights are enshrined in a specific section of the Constitution, in its amendments, or in a particular constitutional declaration, or whether they are contained within an international legal document that the country in question has ratified, so that provisions of such a legal instrument have to be directly implemented. Human rights law is that higher law, or the highest law, with which all other legal instruments, constitutions, laws, bylaws, administrative and judicial acts or decisions, as well as the regulations of non-governmental, public or private subjects must align and not contradict them. If a state or a social order wants to be the rule of law. In this regard, human rights law is sovereign, both literally and figuratively. It is literally sovereign in the sense that human rights law is the highest law, though legally limited because, politically limited, because it has to be determined in line with specifically and historically established human rights criteria and standards. And those standards are something that is politically or morally that's obliged, morally or ethically or politically. And it is figuratively sovereign in the sense that human rights law limits even the high state authorities, the constitution maker and legislator, as well as the Supreme and all other courts, even the Constitutional Court or a similarly functioning body, and any other state authority or holder of a state power, including the people as demos, be it in the case of a referendum, a new constitution adopting procedures, a procedure or parliamentary elections. Human rights law limits in the same way all other actors as well in the societal order, which is and wants to be the rule of the law. So the rule of law presupposes sovereignty of human rights law. Today, it is so easy to respond to the question which human rights should be established, proclaimed, and especially respected in order for national or supranational societal order to become a rule of law. It is easy because today human rights are legally positivized and not only a part of and not only positivized as a part of national constitutional law of singular states, but also as both universal and regional positive international law. Accordingly, human rights are no longer only natural rights, no simple political or ideological demands or ideals. The human rights law is a part of positive law, national as well as regional and universal international law. At the same time, universal and relevant regional international human rights law represents the benchmark for the validity of singular national constitutional laws, statutes, as well as decisions of courts and reviewing tribunals in human rights matters. When discussing the universal international human rights law, the distinction should be made between peacetime and wartime circumstances. It is well known that in the peacetime circumstances, the human rights that today have to be respected by all are identified in the UN Universal Declaration of Human Rights and the international covenants on civil and political rights and on economic, social and cultural rights. Both of 1966 came into force 1974. That is to say, half a century, we have universal standards for the peacetime human rights law. Because these two last mentioned documents, international documents, have been ratified by 172 states, while 25 have abstained from ratification. However, in wartime, during armed conflicts, the protection of human rights is guaranteed by the 4 Geneva Conventions from 1949, as well as 3 accompanying protocols of 1977 and 2005. which have been ratified in their entirety or with the reservations by 196 countries. These documents thus contain positivized legal standards and norms of universal international humanitarian, by this war, human rights law, which is and has to be an integral part of a country's domestic law, at least for these 194 countries. Finally, it should be mentioned that the sovereignty of human rights has been recently discussed from the perspective of international but not internal law by Patrick McLean in his 2015 book. And in our eyes, the sovereignty of law as sovereignty of human rights law is presupposed in the rule of law as law's rule, as discussed by Gerald Postema in his 2022 book. I thank you for your attention.
Thank you very much, Professor. In order not to waste time, we are moving on to our third speaker for today, Professor Igor Milinković. Some thoughts. You want to sit here? Yes, there's also remote, but this is probably simpler.
Sorry.
No problem. Let me just set up the camera so it focuses on you. Or where I am right now, but actually it will be this and video.
I use laptop. So. Hello again. Presentation. So I'm using this opportunity to congratulate the organizers, particularly Professor Hasanbegović and Professor Milinković, but also all other members of the organizing committee. In my presentation, I will share some reflections on the recent book written by Jeremy Waldron. These papers collected in this book are not new. He published it earlier, but collected at one place, they demonstrate a sort of synergetic effect. First, I will briefly explain some of the main points of his understanding of the rule of law and give some remarks regarding the concept of the rule of law in general. And then I will analyze some of the issues of the AI application from the perspective of the Jeremy Waldron's theory of the rule of law. As George Fletcher pointed out in one of his books, rule of law is the most puzzling of all the dreams that drive men and women into the streets. I will make a small digression. This picture was made by a chatbot. I asked it, or he or she, to make an image based on this sentence written by George Fletcher. So we can see how chatbot imagined this remark. And it is a sort of a mechanical sum of the parts of this sentence, which is potentially relevant for the other part of my presentation. So he just put at one place people were driven at the streets, dreamlike sequence, justice, and so on. As Jeremy Waldron pointed out in, not just in this book, in some of his previous papers, always essentially contested concepts, but in his opinion, it is not hopelessly confused. And he started this book with a definition of the rule of law as a requirement that our social, political, and economic life together should be governed by law. There are a variety of the rule of law definitions. I won't explore this issue in more details because you are familiar with these classifications. The most common classifications have been given by Craig, classification on formal and substantive theories, also thick and thin, legalistic and non-legalistic, according to Barber, and the approach that is, I would say, the most suitable, offered by Brian Tamanaha. Difference between formal and substantive versions of the rule of law definition, but also some other sub-classifications within this main classification. So, what is common, one might say, when we talk about rule of law definitions, is that formal part. So we can talk about a sort of a consent regarding the formal elements of the rule of law, such as generality, clarity, prospectivity, and so on. But there are also substantive theories, and the example that is most often mentioned within this discourse is Tom Bingham theory of the rule of law, where one of his principles of the rule of law is the fifth principle that the law must afford adequate protection of fundamental human rights. So what about Waldron's understanding of the rule of law? Following Fuller, he emphasizes the connection between the rule of law and the value of human dignity. For that reason, some authors define his theory as dignitary theory of the rule of law. According to Waldron, the rule of law expresses a powerful commitment to dignity and respect for the dignity of human agency in the forms and procedures it requires for law. I want to talk about his understanding of human dignity, although it is very relevant. He understands dignity as a sort of special status or standing within the community and the legal order, as he pointed out in some of his papers. We are all aristocrats now, which is different compared to some earlier parts of human history. According to Waldron, dignity is a special status attributed to individuals grounded in their recognized capacity to control and regulate their actions based on their own understanding of applicable norms and reasons, to provide an account of themselves, and to rightfully demand that their agency and presence among others be taken seriously. As Walter pointed out, the theories of the rule of law are mostly listish. Authors offer the lists of the rule of law requirements, and his list is mostly formal and procedural. in perhaps too strong remark, Waldron wrote that the pages of the law journals devoted to the rule of law issue often read like a set of footnotes to the scholarly work of Lon Fuller, and they emphasize the formal features that Fuller drew attention to, such as clarity, constancy, prospectivity, consistency, practicability, and generality. He added some procedural elements, although we can find many of these procedural elements already in Joseph Raz's list of rule of law requirements. According to Waldron, requests for impartial and independent tribunals, the right to be present at trial, legally represented, to present evidence, and so on, the right to receive reasoned justification, which is also relevant from the perspective of the AI application, and the right to appeal decisions to a higher body. His conception is relatively thin. He analyzed the question of the possible introduction or inclusion of substantive elements within the list of the rule of law requirements. And his conclusion is that such inclusion is not acceptable. He's clear about that, and his arguments are very close to arguments that are also raised by Joseph Raz. But in his last year paper dedicated to the Gerald Postema's book, Professor Hasanbegović talked about that book. He mentioned the possibility that some of the so-called substantive rule of law values arise naturally one way or another from the formal or institutional aspects of the rule of law. And he wrote that it need not be part of the thin thesis, which he argues for, that there are no connections of any sorts between the rule of law and substantive values, but he didn't elaborate this thought in more details and in that paper, and he's clear that, in his opinion, such elements are not part of the rule of law concept. Very interesting part, and it is related with Professor Pavčnik paper or presentation. He also insists on the thoughtfulness as an important aspect of the legal order functioning and the rule of law understanding. And I will quote a part of his arguments. Thoughtfulness should be understood as an attempt of reviving the classical connection between the rule of law and reason, countering efforts to reduce legal practice to rigid mechanical application of legal forms. Although the rule of law is often linked to the precision, determinacy, and predictability as formal elements of the definition, it is not supposed to turn us into machines. And the important part of this requirement is the use of standards and principles. So, a few brief remarks regarding the AI threats to the rule of law. In the book that I often quote, written by Aidid and Alari, they talk about legal singularity. It is not part of reality at the moment when we talk about functioning of legal orders. But some of the elements that they analyze are already present, and I will point out some of them. According to their opinion, legal singularity, which will arise when super artificial intelligence will be created, will provide for a state of absolute legal certainty and completeness of law. The legal singularity is the idea that law will reach functional completeness in the sense that practically any legal question will have instantaneous and just resolution. So, to make connection to the Jeremy Waldron's understanding of the rule of law, there are many potential benefits of the AI-based systems application, and many authors write about the contribution of the AI-based systems to the impartiality of legal decision making. It will secure more legal certainty, more predictability, but there are also many problems related to the also predictability, especially when we talk about machine learning, transparency, because most of these systems are non-transparent, which is also addressed in the recently adopted European Union AI Act. Also, AI application can jeopardize contestability as an important element of the Waldron's understanding of the rule of law. Also, it can cause hermeneutic injustice. I talked about that in some previous papers. So according to some authors, computational law brings epistemic opacity to the legal systems, which poses significant challenges to the interpretation, self-application, and contestation of the law. And some of the examples of such systems is CEENJ, which was implemented in Netherlands. Also, impartiality can be jeopardized, but I won't talk about that in more details because I will try to respect time limit. So, to conclude, I will make some remarks regarding the Jeremy Waldron's demand for thoughtfulness within the legal process. As I already mentioned, thoughtfulness implies the application of standards, which, according to Jeremy Waldron, is not unacceptable. Actually, he believed that it will secure the realization of this value, and also principles. However, the question is, what will bring the application of AI-based systems? Authors that I already mentioned, Adid and Alari, talk about completeness of law, not in the sense of definiteness of the legal system. It is definitely completed, but as gapelessness, non-existence of legal gapes. And in their opinion, there are some forms of directives that can improve the completeness, and according to their opinion, although legal certainty within and predictability within the legal order, although that is questionable. And they mentioned dynamic rules and micro directives. Sorry for the low quality of this picture I made by myself. So we can see at this picture how they define the position of dynamic rules and micro directives. Micro directives as an extreme example of highly personalized directives. For example, you are driving the car and at the display in your vehicle, you can see the directive that because of your driving experience, weather conditions, type of vehicle and so on, you should drive at specific speed. So at that moment, that directive is created for you as the participant in the traffic. So it is really questionable how would the introduction of such directives would influence the thoughtfulness as the requirement, according to Žgur Waldron, of the rule of law. And just to briefly conclude, regarding the relevance of Žgur Waldron's understanding of the rule of law, it is a novel approach, is following some older authors, but some elements of his understanding are very important, in my opinion, especially the connection between the rule of law and the value of human dignity. And when we talk about the threats of the AI application, also there is a high significance of Waldron's conception of the rule of law for addressing such challenges. Thank you very much. I hope I wasn't.
Thank you very much, Professor Milinković. We don't have to. So I have to thank all the speakers for respecting the time limit. We have some papers here to remind you of the time, but they weren't necessary until now. So our final speaker for this session is Matija, who will be talking about infra-law, nudging, and the rule of law, a challenging relationship.
Thank you very much. Before I start, just two brief comments. First, I have to apologize because the title promises speech of infra-law and nudging, but because of time constraints, I had to choose between one of two. And I think that nudging is more interesting of a test case for the kind of analysis that I'm proposing here. So I won't be speaking about infra-law. The second comment is that I think it's quite fortunate that Professor Milinković spoke just before me, because the model of the rule of law that I'll be proposing is the one presented by Professor Celano from Palermo, and he relies quite heavily on Waldron. So you will see a lot of things that will remind you of what Waldron says. So I should start this presentation with just two very simple comments or claims. First is that law is a mechanism for the exercise of social power. And secondly, that law has to possess certain formal characteristics in order for the power that is exercised through law to have certain characteristics of its own that we also all should agree that are positive. And these characteristics are publicity, rationality, and non-paternalism. So in the first part of the presentation, I will examine Celano's model of the rule of law, which spells out these characteristics and how they're to be obtained. In the second part, I will focus on nudging and show how the power that is exercised when this instrument is used is not always public, rational, or non-paternalistic. So on Celano's view, the law operates as a way of exercising social power since it is a way of making people behave in a certain way. In particular, the law subjects the actions of individuals to the guidance of coercive rules. Now, rule guidance may take different forms and pursue different aims. For instance, it may seek to manipulate its adversaries into feeling confusion, despair, guilt, etc., by requiring of them to do something impossible. This, however, is not how law usually operates. In fact, Celano calls this non-standard guidance. On the other hand, if legal rules do comply with certain formal conditions, those promoted by the formal rule of law, then the kind of behavior guidance sought by such rules is called by Celano normal or standard guidance. Now, as we well know, according to Fuller, the mentioned necessary formal characteristics of law are generality, publicity, prospectivity, and so on. Now, when legal rules possess these characteristics, their behavior guidance will typically have two characteristics. First, it will be efficient, and second, it will be respectful of the dignity and autonomy of its adversaries. Now, crucial for my purpose today is Celano's conclusion that when the law complies with these characteristics, the power that is exercised through law has the following characteristics, as mentioned: publicity, rationality, and non-paternalism. Now, let's look at them briefly. So first, publicity. And here I should point out that this kind of publicity should not be mistaken with publicity as one of Fuller's characteristics of the rule of law. So Celano says that the rule of law is publicly exercised power. On his view, this means that in order for the prescribing to work, the subjects need to understand that and how this mechanism works. Crucial in this understanding on the part of the addressees is a complex set of the lawmaker's intentions. Thus, it is fundamental that the addressees know that the lawgiver requires of them certain behavior, and that she so desires as a consequence of issuing a specific prescription. At the same time, the lawmaker has to know that the addressees know these intentions of hers. In other terms, the intentions of the lawgiver have to be common knowledge between her and the addressees. This, of course, holds for standard action guiding only. On the other hand, when the lawmaker systemically violates one or more formal rule of law criteria, the reasons for doing so are usually kept secret and are therefore unknown to the addressees. Second, rationality. Now, already in his discussion of the publicity of the rule of law power, Celano says that on the standard model of guidance, the lawgiver assumes his addressees to be capable of detecting a complex set of nested intentions. Assuming this capacity seems to me to assume a high level of rationality of one's addressees. On the other hand, on non-standard action guidance, the lawmaker who, for instance, issues impossible prescriptions may be acting instrumentally rationally if, for example, she wishes to induce in her addressees a feeling of guilt. But this is not the kind of rationality Celano has in mind. According to Celano, the model of guidance through rules, when it pursues standard aims, is a rational mode of guidance since it relies on and in the first instance leaves room for the subject's calculation and deliberations. Finally, non-paternalism, which is intimately related to treating addressees as rational and autonomous agents, that is capable of making their own calculations and deliberations on the basis of relevant facts. Now, in this sense, then, non-paternalistic behavior guidance is fundamental for treating the addressees of prescriptions with appropriate respect or dignity. Indeed, paternalism means precisely exercising power over someone in ways that takes away from them the dignity of being treated as responsible agents capable of autonomous choice. This can be done, for example, by lying to them, secretly manipulating their decision-making environment, or even their preferences. On the other hand, it is characteristics of standard guidance through prescriptions, thus of the formal rule of law power, that it gives the subject a choice, says Celano. Now, having very briefly looked at this Celano's model of the rule of law, I will now turn to examine if choice architecture or nudging satisfies these requirements. However, before I do that, I should specify that Celano's model is built around legislation alone, but he himself gives no reason to think that only laws or statute should comply with the formal rule of law criteria. So I take it as a given that all kinds of prescriptions should also comply with this formal rule of law criteria. Now, choice architecture has to do with organizing the context in which people make decisions, with nudging being the mechanism through which choice architecture operates. In particular, according to Sunstein and Thaler, nudging is any aspect of the choice architecture that alerts, that alters people's behavior in a predictable way without forbidding any option or significantly changing their economic incentives. Now, choice architecture is in many aspects radically different from how traditional legal regulation operates. Most crucially, nudging does not resort to commands, prohibitions, sanctions, etc., in order to direct behavior. It is therefore foreign to the use of law as a coercive mechanism. In this sense, but by not imposing coercive behavior guiding rules upon its addressees, it does not offer them specific reasons for action. As a consequence, as we will soon see, nudging is radically different from traditional legal regulation, also in the sense that the kind of addressees it presupposes is not a fully rational agent, here understood in the sense of someone acting on reasons. Instead, choice architecture in general operates by manipulating the context of the agent's choices, presupposing that the individuals are only limitedly rational, conditioned in their choices by reasoning errors, emotions, ideologies, and so on. Thus, on this approach, the decision-making context exerts subtle influences on choices, influences that largely depend on the automatic processes that take place below the filter of conscious rational control mechanism. These decision-making processes, though diverse and partially unpredictable, nevertheless do exhibit broad regularities. Although these regularities do not permit accurate predictions about the spontaneous choices, they do nevertheless allow for sufficiently accurate predictions about the frequency of specific choices within a given context. The empirical knowledge of these regularities allows for the arrangement of the decision-making context in a way that exploits them to steer the agent's pre-choices towards the desired opinion. Choice architecture, therefore, only increases the possibility and frequency of the agent's choosing the desired option. This said, it should nevertheless be pointed out that public policies in the pursuit of whose goals nudging regulation is employed are themselves, at least in part, made out of coercive rules. It would therefore prima facie seem reasonable to examine these rules that contribute to the design of the decision-making context from the perspective of their compliance with the formal rule of law criteria, so Fuller's criteria. However, seeing how it is not these rules that form the grounds of the agency's decision, this does not seem to me a very relevant line of investigation. In fact, I will here presume that such rules, that is, the rules that constitute the framework of specific public policies, comply with the formal rule of law criteria. Nevertheless, despite this being the case, I will show that the kind of power that is exercised when nudging regulation is employed is not necessarily public, rational, or non-paternalistic. So let's start with publicity. You will remember that formal rule of law is public, power is public when the addressees know what is required of them and why, and this is common knowledge between them and the lawgiver. Nudging, on the other hand, is typically defined as manipulation of choices of addressees in a manner unbeknownst to them. This would therefore suggest that it is a secret form of exerting power, and thus a form of power that does not treat individuals with the required respect. In truth, however, this conclusion has to be somewhat qualified. Now, precisely in reference to this manipulation objection, Stunstein and Thaler present a three-pronged defense of their approach as a transparent one. First, they argue that our choices are always influenced by the context, so we cannot avoid nudges. Second, they say that nudges do not limit the original freedom of choice. Third, they rely on Rawls's publicity principle, according to which, simply put, governments are banned from selecting a policy that it would not be able or willing to defend publicly to its own citizens. Now, Haspen and Jaspersen, however, have argued against the sufficiency of Rawls's publicity principle as a safeguard against non-legitimate state manipulation of people's choices. First of all, they say that in any case, being able and willing to publicly defend a given policy, should that be necessary, seems quite compatible with straightforward paternalism. But secondly, they mount an attack against these two authors by examining whether nudges actually constitute manipulation of choices and not of behavior more generally understood. To do this, they first distinguish between transparent and non-transparent nudges, and then secondly, they employ Kahneman's well-known distinction between system 1 and system 2, that is, between automatic and reflective cognitive processes. Now, they define a transparent nudge as a nudge provided in such a way that the intention behind it, as well as the means by which behavioral change is pursued, can reasonably be expected to be transparent to the agent being nudged as a result of the intervention. Examples of transparent nudges include fly in the urinal, footprints painted on the streets leading to the garbage bin, the use of visual illusions in traffic, and so on. The non-transparent nudge, on the other hand, is defined as a nudge working in a way that the citizen in the situation cannot reconstruct either the intention or the means by which behavioral change is pursued. Examples of such nudges include the shrinking of plate sizes aimed at reducing calorie intake, the change of default options from opt-in to opt-out for registering organ donation, and so on. Now, combining this distinction with Kahneman's distinction between system 1 and system 2, the two authors arrive at a conceptual matrix of 4 types of nudges, of which the truly problematic ones, from the standpoint of the citizen's ability to choose freely their actions, seems to be the non-transparent type 2 nudge that seeks to directly manipulate conscious choices of their targets. Or as the two authors put it, this type of nudge works by psychologically manipulating citizens through underhanded, deceptive, and possibly even abusive tactics. As an example of such nudges, the authors state subliminal advertising and attempts to influence a patient's medical decision-making concerning treatments by the subtle framing of risk and choice options to influence a choice in a non-transparent way. We therefore see that from the perspective of the publicity of nudging, only this kind of nudging is completely opposite to the base principle, while the other seems to be compatible with it. Let's move on to rationality. Now, here we remember that I emphasize that law offers its addressees reasons for action in the form of prescribing norms, prescriptive norms. In this way, law seeks to influence their conscious, reflective deliberations. Traditional legal regulation on the standard guidance model therefore assumes that the addressees of legal prescriptions are fully capable of rational decision-making, that they can thus be effectively guided to the provision of clear, rational reasons underlining and encoded in legal norms. This model, however, is ideological in the sense that it presupposes the rationality of its agents without considering scientific findings about the empirical reality of human decision-making, which deviates from this ideal rationality. Nudge regulation, on the other hand, parts from a fundamentally different position, as it is based on the results of empirical sciences, such as psychology, cognitive sciences, behavioral economics, and so on, about the actual human decision-making. The model of human rationality as the basis of nudge regulation is, following Herbert Simon's work, that of limited rationality. Simon's model argues that people do not always make perfectly rational choices due to constraints such as limited information, cognitive capacity, and time. Instead, they are subject to cognitive errors and biases and use heuristics and satisficing. Nudge regulation thus exploits scientific insights about the proneness of individuals to biases and heuristics by designing interventions that guide people towards specific decisions. For example, people often overvalue immediate rewards over long-term benefits, that is present bias, are influenced by how choices are presented, framing, or stick with default options, status quo bias. Nudge regulation uses these tendencies to steer behavior in the desired direction without directly influencing choices. We therefore see that nudging is a form of normativity that does not offer its addressees reasons for action. Instead, it treats them as psychologically predetermined, more or less predictable responders to specific kind of manipulative inputs. Nudging power is therefore not power for rational subject as Celano would have it. And finally, let's just look at non-paternalism. Now, the gist of non-paternalistic action guiding is that the prescriptions allow individuals genuine choices regarding their actions. Simply put, the law tells you something like, I expect you to act in a certain manner. If you don't, I will expose specific harm on you. But at the end of the day, the choice as how to act is yours. In this way, individuals are treated by the legal system as autonomous agents and with the required respect. With nudging, things are more complicated. Now, in naming their project libertarian paternalism, Thaler and Sunstein argue, on the one hand, that in general, people should be free to do what they like and to opt out of undesirable arrangement if they want to do so. Autonomy in this way seems to be preserved. On the other hand, however, the approach they propose is declaratively paternalistic because private and public choice architects are not merely trying to track or to implement people's anticipated choices. Rather, they are self-consciously attempting to move people in directions that will make their lives better. Now, two factors seem to be crucial in legitimizing the nudge project as freedom preserving. First, the fact that paternalism at work is, according to these two authors, a relatively weak, soft, non-intrusive type of paternalism because choices are not fully blocked, fenced-off, or significantly burdened. More importantly, the choices that the nudgees take are supposed to improve the quality of their lives. Crucial in this argument is the claim that this improvement is supposed to be such that the citizens themselves would have judged it positively. In other words, they would have themselves chosen the course of action were they to have paid full attention and possess complete information, unlimited cognitive abilities, and complete self-control. Now, this argument to me seems very problematic. It is problematic for two reasons at least. First of all, because it very openly argues that individuals, due to being limitedly rational, are not at all good at making choices that would be beneficial for them. Thaler and Sunstein argue that it is false that almost all people, almost all the time, make choices that are in their best interest or, in the very least, better than the choices that would have been made by someone else. So the idea is that real-life individuals tendentially do not make decisions that are in their benefit. On this account, however, there is someone else who does know what is good for them. This someone is, of course, the choice architect. Now, this seems very paternalistic to me. But the argument is further problematic because while nudging is, as we have seen, based on findings of empirical sciences about the actual human decision-making, the theory also relies on the idea of a fully rational individual as a justification for the choice architect's intervention. Here, however, while professing to look at the ideal well-being of the nudgee, the theory actually assumes that it is the nudger, that is the choice architect, that is fully rational and thus knowledgeable of the nudgee's interest. The theory is therefore not only very much paternalistic, but it is also based on a very problematic assumption. As one author argues, if all nudge is based on the idea that human rationality is limited and continuously subject to errors, why should it be assumed that the nudgers and the institutions that make use of them are any different? Now, in my presentation, to conclude, I've tried to show how the power exercised through nudging is not respectful or is not the kind of power that is supposed to be a rule of law based power. Of course, nudging is a regulatory mechanism that is increasingly becoming important in regulating human behavior, not only in the private sector, but also in the public sector. So my question is, can the nudging used in, especially in the public sector, be so modulated or reformed that it becomes rule of law compliant without, however, compromising those characteristics that make it useful for the choice architects at hand? Thank you.
Thank you very much. Now that we have heard all the presentations, I am opening the discussion. Since we've had a part of the discussion already, due to Professor Pavčnik having to leave, we have half an hour for discussion now, and Professor Isabel Trujillo has raised her hand. Professor, go ahead.
Thank you very much for all the presentations and for the floor. I have some questions. For Jasminka, I will say that you were speaking of supremacy of law more than of human rights, more than sovereignty of human rights. But my problem with your assessing that human rights law is the highest and then is the very the real sovereign of law, is that it seemed to me that it is possible to say that positivation of human rights is not closing the necessity of recognizing new rights or, you know, or even changing in some way the way in which we protect rights. And then the problem with the supremacy of human rights law over the rule of law is about my difficulties to see just one of these principles as supreme. It seemed to me that in some way the rule of law is necessary also for the practice of human rights, and because, you know, speaking of human rights is speaking of the practice of protection of human rights. And from this point of view, I see, I don't want to become an obsessed with reflexivity. I think that the problem is with sovereignty and supremacy, that are things that, you know, you cannot share. If I am the supreme source, you are not the supreme source. And if you put human rights law at the highest level, you are saying that the principle of the rule of law is not at the highest level. My problem is about the possibility that we need the rule of law for applying and using the rule of law, the human rights law. I don't know if I explain myself. I think that the rule of law as an essence of law bring us to change also the words, and I think that sovereignty is not a good word for speaking of the rule of law. That's my comment. For Igor, if I can call you Igor, there is a point in your there was a point in your presentation that I want to underline. You speak of formal as minimal definition of the rule of law, and I'm not sure that formal means minimal, and I don't agree on the idea that minimal means just adopting the less short list, the shortest list of requirements, as you as I thought that you were saying. We can give a minimal definition without using requirements and saying just the goal that I'm pointing at, the goal of the rule of law, that is limiting arbitrariness. This is a minimal definition of the rule of law. It is not, from this point of view, it is formal in my opinion, but it is not just, diminishing the number of requirements. And for Matias, I enjoy your presentation on Bruno Celano's view, and I agree with you that the problem of nudging is not a good example of the rule of law. But my perplexity is I discussed with Bruno this point, is about the redundancy of non-paternalism in the list of elements that defines the rule of law. My question is publicity. Do you think that publicity and rationality are not? Don't you think that publicity and are not enough for describing his concept of the rule of law? And perhaps the next question will be, which are the differences between his and Waldron's definition of the rule of law? Thank you very much.
Thank you for the questions. I presume we'll be answering in order.
Thank you, Isabel, very much. I know some of your thoughts and dilemmas because we had the opportunity to discuss this matter, and whenever we do it, I always notice something that should be said more precisely, and I thank you very much for that. Let's put it in this way. If sovereignty is sovereignty of law, something that is necessary for determination of the rule of law. Yes or no, depends on how we define sovereignty. can we use another word and maybe another concept that is much more precise? Yes, you notice that would be supremacy. And why supremacy of the human rights law precisely? Because if we do not have that element, then we do not have a content of that law that should rule, at least so content-wise decided and determined at it as it should be. In that sense, if we don't have that criteria, that content of the rule that should rule of law or law that should rule, we can object very, very it's difficult to object anything to Third Reich. Everything that was done there was almost everything was done according to law. There is no camp that was erected without legal rules. There was no anything that was done. People that were killed, their properties that was taken from them, and everything that was done according to some rules. So if we try to determine what content, let's say minimal content, should have that law, and in my opinion, when I think about law, I do not think just about general rules and regulations in constitution and in laws and bylaws and so on. I think, when I think about law, I think about legal order. That is not something that is prescribed, but also the way that it is applied. And we need some minimal content, and that is my eyes, human rights law, though I accept fully that when we take human rights separately, the phenomena is contingent. It depends. Historically is determined. Depends on our culture, general culture, legal culture, and so on. Yes, there is something that is content-wise determined, and we have some experience, and we have some histories and national and international and so on and so on, and we improve those mechanisms of implementation that also belongs to the whole story. But simply to put it, can we have a precise idea and theory of rule of law without a concept of sovereignty? Yes, supremacy is enough. But can we have idea of rule of law without precising, determining content of the law? That also is possible, but then we have to take into account those experiences, historical experiences like Third Reich, to take into account and to not to disqualify, but take it also as the rule of law. If not, then we have to have this content that should be in different countries developed in different ways, and that is something that is, in my opinion, that we have to count. There is no possibility to regulate. That would be too much normativistic, and that would be kind of normativistic optimism, that we can just regulate something and then that we are going to have as a result that goes without saying as an order that should be qualified as a rule of law. It is always something that has an ideal and approaches or backslides to something that is in some appearance similar to the phenomenon, but has a lot of shortcomings, as we see that in most developed legal orders of nowadays. I'm not sure that
Yes, thank you.
I thank you.
Thank you very much for your question and the opportunity to clarify a part of my presentation. When I talked about minimal definition of the rule of law, I talked about that a minimal set of principles or requirements that is mostly accepted by a majority of the authors. Although shorter and more effective definition can be offered. For example, Postemas. I also mentioned Jeremy Waldron's introductory, so to say, definition of the rule of law. But then we need to operationalize in a way that definition, and we come to the list. And in that sense, I agree with Waldron. Most of the theories of the rule of law are listish. So we then start to talk about principles of the rule of law, requirements of the rule of law. Some of them are controversial, but that non-controversial part are formal elements, and for that reason I use the term minimal definition. Although, as I said, the definition that you mentioned is totally acceptable, and it could be considered minimal, and in that sense, I hope that I clarified part of my presentation.
Okay, sure. Okay, thank you, Isabel, for your question. I haven't thought about it previously, but now thinking about your objection, I think there is something to it. I think I understand why you raised this objection. You're probably right. There is a lot of also in Bruno's work itself, there's a lot of overposition between the two elements. And even just thinking now out loud, but individuals in general, from the studies, the empirical studies show us, are not inclined, generally speaking, to make a lot of choices on their own. So I would say that if you have a generally efficient legal system in general, then this also seems to be a kind of proof that people already discharge this cognitive load of decision making to the legislator, so that they prefer to follow rules as some kind of a default option. So I would agree with you that in general, people do not tend to so that they are inclined to accept paternalism where they can find it in rule following, if probably it follows certain characteristics. So the power should be democratic and so on. But after that, when you have these rules in place, I think people will generally tend to discharge the decision-making liberty to someone else. So in this sense, nudging itself is not that different from, I think, other other regulatory mechanisms.
Thank you all. Do we have any more questions for our speakers? Yes, we do. Just turn them on.
Thank you. A question for Jasminka. A very naive and trivial question. Sorry because of that. But in your opinion, this relationship between different level of sovereignty or supremacy, I don't care, which is the role of the highest courts, constitutional courts, human rights courts, with a Latin broker, quis custodiet ipsos custodes. Okay, it's only is sovereignty something which is shared with them or not, and up to which point? Thank you.
Of course, that is that part of my answer to Isabel, that we cannot expect from legal theory the solution of all problems, because there are always something that is meta, and that's why legal philosophy. And concerning specifically this question, so if why to have this matter, this content at the highest level? Yes, when we do as professors in academia, as legal enlighters, and if our profession is legal enlightening, if we are what we profess when we teach, what that is something that belongs also to let's say non-legal duties, not legal obligation, belongs to some professional ethics, and we teach also as judges, teach lay people what is law and what they should or shouldn't do in this or that situation, and they do it not by let's say that raw judgment of justice, but in modern law they have to motivate their decisions, and that justification makes the decision possible to control. And of course, when we speak about those custodians, that is to say, sometimes it is the high court, Supreme Court, sometimes it is constitutional court, sometimes it is an international court, that says this or that. And of course, we cannot say in advance how or if at all some decisions, some court decisions, international or domestic, or will be applied. Tanasie said something, was it at the beginning, about implementations of constitutional court decisions in this country as a problem, and not just constitutional court decisions, but simply court decisions. And yeah, that is also a problem. And that's why I prefer a concept of law as legal order to concept of law as a set of legal regulations. Yes. And of course, it is important. Legal dogmatics is important. That is, of course, that is something that is the first step of knowing about, but is not enough. That is why we need legal theory and legal philosophy, because if we try to think about those propositions, those regulations, even to think about court practices as a serial of decisions, and to judge upon them, we need some criteria. And what is our criteria? Not just those norms that has as a content human rights law, but also the whole experience, historical experience, and a comparative experience. We know a little bit better. I think we should know a little bit better than legal dogmatics, and it is always the question how we are going to use our knowledge, and that is something that is personal, and you cannot say it in advance. We have very, very knowledgeable lawyers who are ready to put their knowledge to serve the dictator and not the interests of demos. But also demagogues do the same thing when it is when it comes to people to decide who will rule in the next election period. There is no solution for that question. Quid custodian. Yeah.
We have 5 more minutes, so there's time for one more short question, and we have a question. Turn on the mic.
To Professor Hasanbegović. First, I would like to say that I think the notion of the concept of sovereignty is really important. And I'm not sure supremacy, and I would like your opinion. I don't think supremacy is enough, because sovereignty means no other can do. There's no other way to do a thing, to enforce a policy other than law. While supremacy might mean that there are other ways, for example, I don't know, administrative acts or anything like that, or pure acts of will over enforcement, other than law, which has specific characteristics, a hierarchy where human rights are on the top, and stability or publicity and all the rest. And I would like to to offer a non-ideal example from Greece, where there is legislation that does not violate human rights per se, but changes so frequently that many times destroys the plans, the evolvement, the development of the personality of the citizens and the non-citizens because of these changes. People make efforts or even invest in personal time or financially to plans based on expectations by law, and then the law changes in a way that reminds raw sovereignty, raw will without justification. So I think that sovereignty is important. I think this is Postema's way to put an end in sovereignty as a political concept. I think just like Uffender said, natural law is sovereignty of the state, period. So actually we have no natural law. Postema says now sovereignty of law is important. So law is sovereign. Forget about sovereignty and the change of will and willkür in general. But I would like just to add that if you would agree that the positivization of human rights is really important also. I mean, human rights not as an abstract concept, but as positive law, a stable, public, intelligible is the actual sovereign. Would you agree to such a thing?
Yes, yes, I agree, because we have the same problem here in our country. So I studied as a practical problem, and I cannot say now without these papers the numbers of very, very important codes, not just statutes, that changed a lot, and that may make total uncertainty, legal uncertainty in country. So I fully agree, but you know, you cannot change by law, not by, especially not but by theory alone, the situation in the country. It is something that belongs also to politics and policy of the legislator. And if the legislator has that majority and for a long period and can do this and that with laws, you can put it to the constitutional court to some extent. To some, you cannot. For example, great majority here is totally against any idea of let's say possibility to legally regulate homosexual partnerships, and it is though it is there are something in the constitution, and there were some propositions to the legislator, and something was accepted because it is accepted from the West that we accept something like that. But the majority opinion is that much against that I really don't see the problem is we should change a little bit political and general and legal culture of the majority. And to explain some things, that it is not a fact of decision, but people, it is, let's say, something that is biologically determined. And say and make it clear what research was made in genetics and genes that are identified that turns these people in this or that direction, and to make some phenomena to be seen otherwise. Law is not omnipotent and cannot change everything.
Thank you very much, Professor Hasanbegović, and thanks once again to all speakers and all participants in the discussion. We are having a lunch break now, and we are continuing with our afternoon sessions at 3 o'clock sharp. To our online listeners, sorry that we can't invite you for lunch, but if you can keep listening in the afternoon, we will be happy to have you here. So the lunch is right here in the Professors Club, and thank you everyone once again.